In the previous video, we have already discussed 14 important questions relating to Mohammedan law. And the 15th question is that examine the significance of Dower under Muslim personal law. And question number 16, the fact is that Mahr or Dower, neither consideration nor dowry. It has a unique position of its own. What is dower? Discuss the nature, amount, claim of dower and dower when payable. And question number 17, whether dower is a sale price of a Muslim wife or a restriction on unlimited power of a Muslim male to pronounce talaq, or it is being given as a token of respect. Discuss. And question number 18, define Hiba and discuss the essentials of a valid Hiba. And question number 19, differentiate between Hiba and Hiba-bil-iwaz. Discuss about the revocation of gift. And question number 20, what are the essential conditions for a valid will under Muslim law? Discuss the limitations under the Muslim law on power of making valid will. And question number 21, discuss bequest for pious purposes under Wassiyyat. What is Marj-ul-Mat? And question number 22, state the basis of right of preemption on the sale of a house by a Sunni Muslim. His neighbor brings a suit for preemption on the ground of vicinage. During the pendency of the suit, the neighbor transfers his own house to third person. Decide. And question number 23, define Sufa and the classification of preemptors when the right of preemption is lost. So, regarding all these questions on the topics such as dower, hiba, Wassiyyat or will, sufa or preemption, already we have uploaded separate videos, and those videos would be sufficient reference for correct and exact answer for all these questions. So, regarding dower, is it a sale price? No, neither it is a consideration. It is being given as a token of respect. And regarding that, we have already discussed the pre-Islamic form of marriage, that was bina, where the wife stays at her home and the husband gives a gift, and that is known as sadak. And in the ball form, the wife accompanies her husband, and the husband gives certain amounts to the parents of the wife, and that was meher. And after Prophet Muhammad, he combined both sadak and meher, And from there, the very importance of mahr or dower became important under Islamic law relating to marriage or nikah. And the very quantum that deals with mahr as per the Sunni school, and among those it may be not more than 10 dirhams, not less than 2 dirhams, and among the Shias, it would be 500 dirhams. And as already we have discussed, dirham, then it was the official currency of Saudi Arabia, and at present it is the official currency of United Arab Emirates. And Dow is basically two types. One is specified Dow and the second one is proper Dow. And the very specified Dow is divided into two parts. One is prom Dow and the second one is default Dow. And as this is specified Dow, it is itself mentioned in the very Nikanama, and regarding proper Dower, it is decided by the judicial or by the court, and the wife has the right to remission of her dower demand against the husband, and dower is also under Islam is considered as a debt, and there are certain rights to the wife in case dower is not given, over a right of retaining the very property of the husband until the dower is paid. And while retaining such property of the husband, the wife has certain responsibility and obligations like to provide all the details of income and profit she received out of the property of the husband that he retained to the legal heirs, and in certain occasions also the wife loses her right of retention of the property of the husband. And regarding Hiba, as already we have discussed in our previous video, it is otherwise called gift in English, and there are certain essential conditions to be followed to make a valid Hiba, such as capacity, and that capacity is considered as two types, the mental capacity and the financial capacity. So also the very subject matter of the gift about which the person who makes hiba or gift has exclusive ownership and possession over that property. And so also there must be a donee, and the donee must accept the gift. And besides that, to make a valid hiba, certain formalities are maintained, and so also the very person who makes us hiba or gift has also the right of revocation before the donee accepted the hiba. And so also how hiba is differ from Hiba-bil-iwaz, as Hiba-bil-iwaz is a kind of hiba in return of which you receive certain gifts or certain promises, and that is called Hiba-bil-iwaz. And regarding Wassiyyat, that is a will, and for that a valid will, a Muslim has must be the capacity and must maintain certain formalities or follow certain formalities, and there must be the very subject matter of Wassiyyat. And regarding that, the Muslim who make such wasiyat must have the ownership and control over that subject matter. And so also the Muslim can make bequest for pious purposes and such as those for any Hajj or pilgrimage and for any charity regarding the poor and any other activities such as building a mosque or a bridge or helping the poor and such as considered as basiyat, and basiyat is also can be revoked either by express revocation and by implied revocation. So when it is implied revocation, we can cite an example. Suppose the very subject matter of the basiyat is a house, and before handing over the house to the donee, then suppose the person who makes the basiyat will sold the house to another person, then it would be considered implied revocation of the basiyat. And there are certain other formalities on basiyat regarding acknowledgement of the very subject matter of the basiyat or will. So, in this video, we almost briefly discuss these questions relating to Dower, Hiba, Wassiyyat, and all these topics are separately dealt in our videos in detail, which we have already uploaded in our channel, to which any viewer can make reference to find out the correct and the complete answer to all these questions. So, in our upcoming next video, we would like to discuss preemption or shufa under Islamic law.